Hello to all our participants. Hello to our guest today. Welcome to EBC learning session on virtual courts, managing the new normal. I'm Vijetri Roy and I'm an instructional designer at EBC Learning. Now this particular session is also brought to you by EBC Learning. For all those who are not aware, EBC Learning is EBC's educational initiative where we provide on-demand legal education for everyone. The objectives of EBC Learning are to help remove hurdles to legal education, to empower you to make life-changing moves, and of course, to help you learn and win. Now, all our courses are available at ebclearning.com. And towards the end of today's session, for a few moments, I will share my screen and I'll show you our platform. Now, this particular session, like I said, is live on YouTube right now and will be available on our YouTube channel, which is youtube.com/c/EBC Learning. So all those who have not yet subscribed to our YouTube channel, please do that. And once you have subscribed, also don't forget to click on the bell icon, which will start giving you notifications for each of the videos that we upload or for each of these sessions that we hold, which are live. Now, coming to today's session, we have with us today Amit Gupta. He is an Oxford University and Columbia Law School graduate with over 16 years of experience as a counsel or litigator in New Delhi. He is admitted at the Delhi Bar Council and New York State Bar. He regularly appears before the Supreme Court of India, the Delhi High Court, Competition Commission of India, company law tribunals, and arbitral tribunals. He is also an additional public prosecutor of the Delhi government at Delhi High Court for over 4 years. He appears on behalf of the Department of Prosecution, Delhi Police. Amit has handled a wide spectrum of matters relating to competition law, arbitration law, media, including free speech and content regulation, pharmaceuticals, commercial and business laws, aviation, intellectual property, land acquisition and planning, telecom, mining, consumer law, constitutional and administrative law, and criminal law. Now, for our participants, please feel free to post your questions and queries in the chat tab, which is below your screen. Now, over there, please place your questions so that we can take up those questions towards the end of today's session. That is after our speaker has presented his portion of what he would like to discuss. Also, I would like to encourage all our participants to share details of this particular webinar with your friends and family on social media. Now, coming to today's topic. At present, as you know, that due to this lockdown, we have all started getting tech savvy and we are connecting online from having virtual classrooms to office meetings to courtrooms. Everything has now become a virtual experience. And this webinar has been planned by us to provide an understanding of virtual courts. Now, these virtual courts are a relatively new platform for even seasoned lawyers, judges, and arbitrators who have had experience, years of experience of standing in the courtroom and speaking and orating. Now, during this particular session, Amit will share his personal experiences and practical insight of appearing before the Delhi High Court through video conferencing consistently over the past few weeks since the lockdown. Now, this webinar has been planned to weigh the pros and cons of virtual courts in today's scenario. And we shall also have a discussion on how to prepare for a virtual court hearing, technical challenges, and effectively conduct hearings in a virtual setting. And I'm sure that this webinar session will be useful and helpful in learning basic advocacy skills for the new virtual world. Now it's up to you, Amit, you can start your session. And to our participants again, please feel free to put in your queries and questions in the chat tab.
Hi, good afternoon, everyone. I hope all of you are doing fine in these testing times. Now, as Vijetri has said, that the purpose of this webinar is just to share my experiences of appearing in the High Court through the video conferencing. Whatever I've learned during that process, and maybe it should be helpful for everyone who is participating today. I have prepared a PowerPoint presentation, which I'll just share with you. and let's go through it so that it's easy for us to follow what I want to convey. So this is about the virtual courts, managing the new normal. What do we mean by new normal? The social distancing is now the norm. We really can't go and meet. We can't call people to the offices. Our staff and juniors are working remotely. And likewise, we have seen that the courts are normally crowded. The Supreme Court, High Court, District Courts, you go wherever there is like litigants, the lawyers, the office staff, the lawyer staff. It's virtually impossible to have any kind of social distancing. And we have seen that in India, as well as globally, all the courts have taken steps as soon as the COVID pandemic has spread, and have ensured that social distancing is maintained. In India, for example, the Supreme Court and the Delhi High Court, even before the lockdown was announced, they took measures to ensure that people are not coming to the courts. The litigants' entry was stopped. The number of matters were curtailed, and only urgent matters were being taken up for hearing. Subsequent to the lockdown, there's been absolutely no physical appearance in either of the courts. The courts are working only remotely, and therefore it's important for us to understand as to how the virtual courts function and what is the procedure when one is filing. How do you attend the virtual hearing? Is the virtual hearing equivalent to a real hearing? Even if you are a seasoned counsel and been appearing for a long time before the courts, is it easy to adapt, or there are certain challenges? One of the remarkable differences one feels during the course of virtual hearings is that you're sitting alone in your office, like I'm doing right now on my own. There's absolutely no support staff. You're not even dressed properly. Well, you might be, but it's up to you whether you want to dress properly or not. On the other hand, when you're in the courtroom, you are appearing directly in front of the judges. There's a lot of eye contact. There's a lot of support staff. There's your client who's behind in case there's anything that you need to ask. And there's also lawyers who are observing you. And many a times you have seen that they also come forward and assist you in case there's something. Of the judges also ask counsels who are sitting in the court to assist them. So as Vijayatri has said, I've been appearing before the Delhi High Court on behalf of the Delhi government for a few weeks now, ever since the courts have started hearing through virtual conferences. And it's a sharing of my experiences, which I hope will be helpful to everyone. Now, I said that the virtual courts are new normal. Why do I say that? One just needs to look at what the Supreme Court of India has passed the directions. On 6th of April 2020, the Supreme Court of India took a suo motu writ petition and laid down guidelines for court functioning through video conferencing. And it said that all measures to be taken to secure the functioning of the courts in consonance with social distancing, guidelines and best public health practices shall be deemed to be lawful. Now, after this observations were made, there have been certain voices who have raised doubts about the functioning of the virtual courts post-lockdown or even during the lockdown. We've had certain comments that they do not allow enough time for the lawyers to make representation, and there are inherent shortcomings due to which the virtual courts cannot be seen as a cure to the current difficult times that we are going through. In response to that, Supreme Court issued a note on open hearing. It's not a judicial order. It's just a note which was issued for circulation in the press, in which it strongly supported the current functioning of the system. And it said that virtual courts technology is but just a tool. The institutional requirement to ensure that administration of justice does not crumble in the face of this unprecedented scenario. Virtual court system does not negate the principles of fairness that are sacrosanct to the administration of justice, nor is it failing to adhere to requirements of an open court system. It further said that open court is not an end in itself, but a medium for fair adjudication. Open court hearings cannot be claimed as a matter of absolute right. Open courts necessitates access to litigants and public and or their representatives, but not their bodily presence to get her in any given space, any place. There may be alternate models of open court system in its physical sense. The virtual courts are effecting and fostering the same end and outcome as the physical courts, and that is fair adjudication. Now, there are remarkably strong observations which have been made by way of this administrative note. Along with this administrative note, the Supreme Court also gave a list of countries where the virtual court hearings is now taking place. This was to support that the current system is going to continue in place. As of now, we don't see what is the way going forward. Even if the lockdown is lifted, whether the courts will be back to functioning in normal capacity, whether they would be in a curtailed capacity, whether it would be partly open and partly virtual, it's all in the air. We still need to know. So therefore, it's important for us to understand how do we manage virtual courts, what do we need to learn, and what is the best way of effective advocacy during a virtual court hearing. Now, before we come down to the court hearing, uh, one needs to also understand the filing procedure, because in the normal courts, we are so used to filing physically, specifically in Supreme Court, even though I can say for Delhi High Court, there are various matters in which electronic filing is now allowed, and you do need to, there's no need for any physical filing. But it's still a new game for each of us. Uh, Being reliant on our support staff, we are so used to printing out the annexures, giving them the files, and they will paginate it, index it, collate it, photocopy it, run to the registry, get stamp duty, and do whatever. And the lawyer concerned may not actually be involved in the entire process. On the other hand, if you're in current time, if you want to do a filing before either of the courts or in any other court, it has to be only electronic filing. And electronic filing requires a complete different set of skills. You need to be very comfortable reading the documents online. It's not possible that you are reading physically and at the same time dictating it to a steno who's sitting in front of you. And by the time you're done with the dictation, you would have a rough drought cut out. You need to involve technology as to how you can read online and at the same time ensure that you're dictating or you're typing it out. So it requires, it is quite intensive in terms of time that it would require from you. Insofar as the filing procedure is concerned, the Supreme Court has come out with a standard operating procedure for mentioning e-filing video conferencing. I don't really plan to go into detail as to what are the filing procedures. This is just for the convenience that I've given that the procedure is available on the link, which has been mentioned in this slide. Also, the mentioning application needs to be accompanied with the your paper book, and it has to be a synopsis of urgency, not exceeding one page by email, and you have to send it to the registrar concerned, and it has to be sent well in advance. It has to be sent by 5 p.m. 2 days preceding the date of hearing. Only after which it shall be processed for the date that one requires for listing. The Supreme Court has also very clearly said that there would not be any oral mentioning on the phone. It's been a general practice that during the urgency, lawyers trying to get in touch with the judges directly concerned. Now, that is something which the Supreme Court SOP does not appreciate. Likewise, if one has to file in the Delhi High Court, again, apart from your entire paper book, which has to be filed in a PDF format, there has to be a document which explains the urgency. It has to be 1 page length, PDF format, and it has to be filed on the link which has been given. It has to be done early in the morning. So that is a bit remarkable because as lawyers, we're used to courts starting at 10 o'clock or 10:30. And over here, it has to your urgency request has to be put in before 10:30. Earlier it was till 12 noon, but they have now preponed it. And once you'll get an SMS confirmation if your request is allowed, and then it'll give you a link as to the procedure which is to be followed. You need to make an advance service on the opposite party, file all documents with proof within 2 hours of receipt of the SMS. So this is something which the High Court expects. So therefore, it is ideal that before you actually put in a request, you have all your documentation ready. And when I say documentation, yeah, it has to be the entire paperwork with index and with pagination. And something which I was mentioning earlier, that since you're doing everything electronically, you will need to have tools by which you can edit even a PDF document, or you can collate all the documents online, paginate it, and in case something is missed out, you are able to reshuffle the pages, add the pages, and so everything. It's next to impossible that you make in a request and then expect that within 2 hours you'll be able to push in the documents. And again, the date which, unlike the Supreme Court, which says that it has to be 2 days in advance, the High Court does not fix any particular date, but it's up to the discretion of the registry as to the date that they will be informing you about listing, because they have set a number of matters which can be taken up for hearing on a particular day. So it might be possible that you put in a request tomorrow morning and you will be asked that you will be told that your matter is listed on Friday or maybe Monday next. So therefore, it's imperative that all the documentation is ready before you actually make a request. In case your request does not get accepted, you do have the option of making a request before the designated judge at 3 p.m. on the same day. So that is something which the Supreme Court does not allow, but the High Court does. Now, once you have filed, your matter is listed, and you're ready for arguments. What are the requirements, or what are the steps one needs to take? I have realized that it's extremely crucial to have advanced preparation before you actually start a hearing. And as I said, it's a new norm for us. It's not as if you can rush to the court, put your band and gown, and you will have your file given by your staff, and you can start arguing before the court. You are effectively operating remotely, even though in India the lockdown has been relaxed. You can use your office space, but then it's advised to maintain social distancing. You may not have the entire staff with you, so therefore you are relying on your own infrastructure and facilities. You need to be fully aware as to what is your capacity, how do you use various equipment and gadgets, what is the best way that you would be managing the hearing, and whether you have enough internet connection speed, what are the audiovisual capabilities, whether there's any alternative or backup system or software available. And it's always advised that you test run the setup in advance. Now, since many of you have logged in through Zoom, and it's a webinar, so I'm assuming that all of us are quite friendly and adaptable to technology. And the system which is being used in the Supreme Court and the High Court is no different from Zoom. It's a slightly different platform, but yet it's a different thing if you're chatting with your friends and relatives on Zoom and you're casual, and even if there's a disconnection, you can join in. But you would not want that to happen when you're in the middle of heated arguments, or there are when the judge is asking you something and suddenly you realize that the connection has snapped. So therefore, the Supreme Court's SOP has advised that there should be a bandwidth, ideally of 2 Mbps and above, on a dedicated device. Now, this is important because the Supreme Court says that when you are connecting, you should have your mobile phone free, because just in case they need to get in touch with you in case of any urgency, or any technological issues, you would be in a position to take your call, to take the call. If, on the other hand, you're using you're connecting to the meeting only through your phones, that is something which the Supreme Court does not advise, and I'll be coming on that issue later during the presentation as to why I don't feel that's best way. You also need to have your entire docket, clear document numbering, books, materials available at the desk. Now, in the courts, many times speaking personally for myself, when you're before the court and you're hearing, and in the hearing, you require a Bear Act, and you realize that you're not carrying it. You may look around, you may look at back, you may ask your junior, a clerk, or some counsel who may be carrying the book, and you would have the benefit of that. It's not possible. Now, if supposingly as I'm speaking, I were to get up and go out of the frame and pick up a book and come back, the judges, we all know, don't really have that much of patience, and more so on a virtual court hearing. So it's important that you have all your Bear Acts or whatever material that you need to look into that is available. If you're using if everything is scanned, it's paperless, you know how to look into it. It's not when the hearing starts and when you've logged onto the system and then you're trying to open the folders and trying to go figure out which is the file. Now, if you're using an alternate mechanism or alternate equipment, let's say if you're connecting to computer and the file is on iPad, so you should be ready to do that. Now, whenever in the High Court, whenever I have received the emails which have given the details of timings and what are the passwords and the access ID, I have ensured that I have written it down separately on a sheet of paper. First couple of hearings, it was easy. Yes, it's there electronically. Oh, when I'll open the computer, I'll come to know. But then switching screens, switching windows, it's not that comfortable, at least speaking personally for myself. So I ensure that whenever I have a hearing a day prior to that, I jot down the details on what are the access codes, what are the passwords, what are the specific timings which have been given. Again, you can ask your clerk to check up the list and have a list with you, but it's crucial that you also know as to the serial number on which your matter is being taken up, the bench which is taking up the matter. We all know some benches are slow, some benches are quick. So there's no guarantee that if there's a specific time which has been given to you, it will be taken up at that particular time. And then also have a contingency plan in place. Let's say the Wi-Fi drops down, the Wi-Fi stops responding, and suddenly there's a disconnection. Maybe I'm in a position to connect my laptop, iPad, any other gadget through my phone. Maybe I have a separate dongle through which I can access the internet. Many times it's happened with me. There have been a couple of Wi-Fi connections, and the Wi-Fi connection switches off to another one where the connectivity is poor. So therefore, you need to check up whether the connection is proper or not. So this advanced preparation is something very crucial before I come to lights, camera, and action. Now, I hope this here the things become a bit funny. I would be playing a clip for you just to show as to what I mean by lights, camera, and action. Just focus on the gentleman who's on your screen on the left-hand, top left-hand side. And the meeting is about to end. The meeting actually ends. And what happens during the after the meeting?
Goodbye. All right. Talk to you guys tomorrow.
Bye.
See you guys.
Now I'll pause over here. Now you can see the gentleman on the top left side has got up from the meeting. He's not realized that his camera is still on. and his co-workers are suddenly, they can't believe their eyes, and they're staring at him as to what is he doing. And he's actually in his shorts. He's not wearing anything underneath. And you can see the reaction. So when you are in a court hearing, this is something that you don't want to happen. Now, there's another slide which I have. This is from a news show in Good Morning America. And there is, if you see on the right-hand side, one of the journalists who was reporting from home. Now, I don't know if you notice that while he's properly dressed insofar as his jacket is concerned, he's not wearing his trousers. And this is enlarged version of that. And you can see in the red circle, something's missing. Now, when you're before the court, that's the last thing that you would want to happen. You may be informers, that's good for you. Or you may think that, okay, we'll take it casually. We'll need to dress up only to the extent that the camera covers us. So why do we need to put on the entire dressing? But then be very sure as to how you are placing your cameras and how you are being received. Before the first hearing, I used all the devices which I had within my means possible to work out a way to figure out as to what's the best location, am I being clear or not, and am I being properly visible. Now, I'm pretty sure you can see my background. I'm sitting in my office. I have ensured that there's no one who's coming and disturbing. I'm pretty sure many of you would be doing that for official meetings. But I believe that when you're before a court, it becomes all the more important because when you're appearing in the court, you're really expected to maintain a proper attire. The Bar Council of India rules require you to be dressed properly. Now, we have seen, we've had instances where the judges have asked the counsels to leave the courtroom in case they're not dressed in the attire as it's requested or as it's expected. So therefore, we should, I personally, I've realized that it's better that your desk is near the wall, so that you are not, when you leave or when you get up, as we saw in that video clip, the other people on the chat or on the platform are not able to see as to the long shot of the room. In case someone is appearing, maybe that is also hidden. And during the course of the hearings, it's happened that the judges have remarked. One of the judges made a very casual remark. I'm not sure whether it's still visible in the current frame, but behind me is on the pin drop, I have placed a couple of drawings from my daughters, and they were there. I never noticed. They were there for quite a while. And when I never expected that they would be that visible to the bench. But the learned judge made a remark about it. In one other hearing, one of the judges noticed the long bookshelf behind the counsel for the petitioner and said that the judges now have access to everyone's office or cabin or even drawing rooms. Well, maybe the same is true for the lawyers also. You've had judges who've been attending court hearings from the confines of their home. So many of them now are properly within in their office and expect you to be the same. One of my first hearings was quite remarkable because when even though I had tried to work out my camera placement and how would I appear, the judge was sitting on a living room sofa, and his face was quite far off. And during the period of lockdown, he also developed a beard. So therefore, it was really not possible to make out as to whether it's the same judge or it's a different person who's hearing the matter. But anyways, it's still, as a lawyer, it's important that you ensure as to from where you are attending the hearing and how you're appearing. Some of the lawyers have been using phones to connect. But what I've found is that the face really covers this, the entire screen, and it's not possible to really make out as to what are the expressions, how he's trying to convey. So therefore, whatever equipment, gadget, tool that one has, my advice would be that we ensure that we appear proper as we do in the normal courts. Now, as I was mentioning about the dress codes, here's another clip which I would want to play. This is from one of my one of the movies which I really like, My Cousin Vinny.
You get that? The whole store got the flu.
Now, if you would see the dress, if any of you would have seen the movie, he didn't have the, he was, it was an outstation brief, so as to say, for him. And therefore, he went to the store and was wearing whatever he could. Now, you're pretty sure that's not the dress code which is expected of you. It's a virtual hearing, fine. You're appearing from your office, home. But still, you really cannot be dressed up, let's say, like a clown, or you cannot show your fashion taste to the judges or to the opposite counsels. So therefore, we have to ensure that this dress code, this kind of dress code, is not used. We've had a news report where in the Rajasthan High Court, one of the counsels appeared before the judge in a vest. He was not even wearing a shirt. And the judges remarked quite strongly against him. So that's something which is not to be done. Now, I've also come across in Florida, one of the judge was so annoyed with the casualness of the lawyers who were appearing for the hearing that he actually, the bar association, the local bar association, circulated a letter from him, which was titled as a virtual view from the bench during the COVID-19 pandemic, and a letter from Honorable Dennis Bailey. So in this letter, he goes on to discuss quite a bit as to how the hearings are going on and what is expected. But one paragraph he devotes to the lawyers, and I'll just read it out. It makes quite a funny reading, at least for me. It says, "It's remarkable how many attorneys appear inappropriately on camera. We have seen many lawyers in casual shirts and blouses with no concern for ill grooming in bedrooms, with the master bed in the background, etc. One male lawyer appeared shirtless, and one female attorney appeared still in bed, still under the covers, and putting on a beach cover up. Beach cover up won't cover up your poolside in a bathing suit. So please, if you don't mind, let's treat the court hearings as court hearings, whether zooming or not." And that's true for everywhere. Like, that's true for each one of us. We need to ensure that we are properly dressed. As I understand it, the Delhi High Court has dispensed with the gowns and coats for lawyers who are attending court hearings from the court premises. This is to ensure that there is no spread of the coronavirus. But even if one is not wearing the coats, still one has to be very formal about the court appearance. Now, patience is something which is required when you are attending the virtual court hearings. As I mentioned that we receive emails for the hearings. They mention the access code, the password, and the times at which the hearing will start. But like in the normal courts, it's not for sure. The hearing may be delayed. The hearing may be preponed. And the delay of hearing could take place on any account whatsoever. Everyone is still learning technology. We're all new to the game. There are a lot of technical challenges involved. There have been instances where the judges have not been able to connect to the platform. One of my matters got passed over precisely for this reason, because the learned judge was not able to get onto the platform. There have been instances where the lawyers have not been able to connect. So therefore, even one, the hearing gets delayed. Even if the hearing starts, there could be other challenges which would be there. And also, it's not possible to know as to what would be the actual hearing time. In the courts, we all go in, check up how the matter is going on, how long it is expected. Sometimes we ask the counsels, the briefing counsels who are involved in the matter, how long it will go, or we make a rough guess. That's not possible on a virtual court. You really don't know. You don't have access to the hearing which is taking place prior to you. So it's always, I've found it a good thing to connect with the court masters in advance. The cause list indicates the numbers of the court masters. And sometimes there are matters which are expected to clash. There are matters where if in case you don't know that how long the matter will take. So just tell the court masters in advance that you are appearing in this particular item. You are for this particular, either you're for the petitioner or respondent. And just in case they need to get in touch with you, they may. And it's helped me quite a bit, because many times the court masters will call you and inform you that the hearing in the earlier matter is just about to get over, so be ready and try logging in. Otherwise, there's no way. You keep on punching in the access code and the password, and the screen will, the pop-up will show that the hearing has not started. So therefore, we need to make that bit of advanced preparation. The Delhi High Court expects the counsels to be ready 15 minutes in advance. The Supreme Court generally says that they will send out an email 30 minutes in advance before the hearing starts. And even when the proceeding starts, it may take longer than what you would expect. As I said, the connectivity may lose out. You may not able to hear the judges. Sometimes it's difficult when they're dictating the orders, whether the order has been taken on properly, the date from the court master. So since there are several platforms involved, you have the court, you have the judges, you have the judges' staff, and the lawyers. So everyone having good connectivity at the same time, it's not possible. So one has to be patient. It's while one cuts down on traveling time to the courts or running around, yet it may take and end up taking the same amount of time. And again, when I say patience, I also mean that it's not very interesting when you're sitting all alone on your desk and staring at the screen, waiting for the matters to start. In real courts, we go out in the corridor, we gossip, have a cup of coffee in the canteen while watching the display boards, and rush when the matter is about to be taken up. That's something which is not at all possible. So you need to be patient and at the same time available as you are in the real courts for the matter to be taken up. Whenever you are called for, you should be ready with your arguments. Now again, I'll just play out a small video clip. This is insofar as how one needs to maintain decorum in the courts. In the courts, we all know that the judges control the proceedings. Any lawyer who's not behaving properly, a noisy litigant, the court master or the judges will just ask them to go out, or there'll be other court staff who will take care of any disturbance which is being caused during the hearing. However, that's not possible when you're in a virtual court, because the judges also are on the platform as you are. They, to the best of my understanding, they don't have the option to mute the speakers. The judges, like in today's hearing, the learned judge asked all the counsels except the speaker to go on mute. and only the person who was speaking was put on mute. But I'll just play out this clip as to why silence is necessary, even from the end in terms of the background noises. Now, this is something which has actually happened during the US Supreme Court hearing, and just listen to that.
Discussing and addressing the content of the calls at issue being made by collectors of government-backed debt, and it contemplates that the subject matter of the call might range beyond the collection of government-backed debt. Maybe they're going to be marketing some other product. Maybe they're going to be saying, hey, call your congressman and change these laws that apply to banks. And what the FCC has said is that when the subject matter of the call ranges to the topics, then the call is transformed. And it's a call that would have been allowed and it's no longer allowed.
So you would have heard that there was noise of toilet flush, even as the attorney was making the submissions. Now, that is something which you don't want to happen when your court hearing is going on, at least not from your end. You really can't control what's happening at the opposite counsel's end. So therefore, there should not be any disturbance. It's advisable that you mute the microphone when you are not speaking, so as to it will cut down any unwanted noise which is coming in the background. Avoid speaking together. Now, in the open court also, if the lawyers for the petition respondent start arguing together, it's difficult to make out. The judges really don't appreciate that. In virtual courts, that's actually not possible at all. If two speakers start speaking together, it doesn't make any sense. Also ensure that there's no visual disturbance. If your video is on, everyone is watching, and one has to be wary of the body language. There's no hiding place. In the open court, while the hearing is going on, sometimes the counsels are chatting among themselves or smirking at what the opposite counsel is arguing. Now, if you're in a virtual court, all the speakers are available, and the bench can see the speakers. Even if you're not speaking, they can see your visual expressions, and you would not really want to be in the judge's bad book by making smirks or making remarks at the other counsel. So one has to be very careful as to how one is behaving. Just today in the court hearing, even as the hearing was going on, the opposite counsel was trying to call someone over during the course of the hearing, and it was all very visible. He may not be aware, but every small movement of his body was quite noticeable. Now, the virtual courts give a lot of emphasis on written advocacy. The time which is available during the oral presentation is limited. For example, the Delhi High Court says that the matters which go on for more than 30 minutes, they will be taken up either at the end of the board or on the next day. And something which I'm playing out is not possible in the virtual courts. Now, staring in the eyes of the witness, theatrics, throwing and waving your arms, something which we just saw in this clip, that you can't do in the virtual courts. You may get up, you may wave your arms, but the judge is going to see only as much as the video allows him or her to do so, or whatever your camera capture. And making arguments in high voice, again, will not really make any difference. The judge is sitting distant. It will not matter if you are polite. In fact, it will help if you're polite. If you are screaming and shouting, the audio quality is going to go down. And anyways, the judge is not going to take kindly to that. So therefore, the theatrics and the drama of a courtroom are missing. Your submissions have to be specific, focused, precise. The judges carefully note the pleadings. Your documents need to be circulated in advance. It's not possible that you hand over the document across the bar. Whatever has to be there needs to be properly pleaded. In case you're relying upon a particular judgment, case law, it's advisable you mark it as an annexure, or or at least specifically refer it in your pleadings. It's not possible that you raise grounds and then many times it happens in the courts because of urgency, we file the petition without specifically highlighting the case law. And during the court proceedings, we hand over the judgments. Now, there's no handing over the judgments which takes place in the virtual courts. So therefore, whatever you need to put across has to be by way of written pleadings. So, and that has to be very, very clear and specific when you are before the court. At the same time, there has to be advanced teamwork, which is necessary. In the open courts, in the real courts, we see each side represented by a particular team. A senior counsel would be assisted by a briefing counsel. There would be further counsels who would be available to indicate as to the page number, the correct documentation which needs to be referred to, and pass on the documents. That is something which is not available in a virtual court. There has to be the person who's actually arguing needs to be gadget friendly. He needs to know how to manage in case it's a paperless brief, he needs to know how to manage the software and the applications required. How to shuffle between various volumes in case it's a voluminous brief, or various sets of documents. As I said, there's no passing of notes. There are no verbal, it should be no verbal cues during the course of hearing. Now, there are definitely alternate channels of communication which are available, but they are cumbersome. Now, in one of my hearings, I wanted the assistance of the investigating officer during the course of, in case the bench were to ask particular queries. And I thought I'll have him online even as the hearing goes. But it was just not possible. The hearing the time got shifted thrice, and the hearing started suddenly. There was not much time to have him online. And I'm not sure if even if I had him online during the course of hearing, how I would have managed to communicate with him. Because in case you were to speak with the person on phone, it would mean that you put yourself on mute and the judge will wait for you to take instructions. In one other hearing where there were certain queries which the court had asked and I had to take instructions, the judge said they just passed over the matter and said you take instructions and come back with it. You can have WhatsApp groups. You can have other Skype calls on a different gadget equipment. But when you are arguing and you're trying to focus on one machine, it's not possible that you keep on looking around and shifting. In actual courts, even as we are arguing, we can pick up the files, or even as the judges saying something, we can go ahead and turn around and listen to the queries. That's something which is not possible in a virtual court. And so therefore, it's very important that we have the advanced teamwork, the advanced preparation, and the lead counsel is properly briefed. In one of my matters, the senior counsel who was appearing for the petitioner was not able to join the meeting, and the meeting started. And he tried to get in touch with me. We tried to get in touch with the court staff. And it was only towards the end, when the judge had already made up his mind and was dictating the order, he could join the meeting. So therefore, it's important that we are gadget friendly. It's also important that we use multiple screens, as I mentioned earlier. Like if you're using one screen to connect, then you should have another screen on which you can read your files and documents. If you try to read it on the same machine, you will not be able to see what the judge's facial reactions are. You will not even be able to see how you are appearing before the judge. In the courts, we are so we know the importance of maintaining eye contact with the judges, looking at how the judges are responding to the arguments either made by the other side or by our side, and what would be the next probable query which could come from the judge and how to respond to that. Now, if you were to try to, if you were to use the same screen and read the brief on the same screen, you will not be able to see how the judge is reacting, or when the judge is expecting you to keep quiet and would be asking the other side. So therefore, it's important you have at least two. Ideal would be three, because in case you're connecting through one, reading the files through the other, and if you want to connect through your briefing counsels or any instruction that you want to take from the client, that you can do from the third machine. Now, there are no outsiders allowed, so therefore the clients are not there. You really can't walk into the court and make an intervention. You need to take permission from the concerned court. The judge may not allow. In the open court, the lawyers, parties who are interested sometimes go and make oral mentioning. During the course of hearing, it's up to the judge's discretion, they may allow, but at least they get a chance to appear or at least hear the matter. Now, that's something which is missing from the virtual courts. Even for young lawyers, as Justice Deepak Gupta, just recently retired from the Supreme Court, said that for young lawyers, it's important that they see how the seasoned counsels are arguing. Now, that is something which is missing from the virtual courts. Hopefully, things will change, technology will improve. We will be allowed to access the hearings on a common platform where we could know as to how submissions are being made. But as of now, they are in-chamber hearings. There's a restriction as to who all can appear and who all cannot. The Supreme Court has made it very clear that it will send out a link only for maximum 2 to 3 links. One is for the litigant and 2 links for the lawyers. So we one for the senior counsel and one from the briefing counsel. And at the same time, the issue is of accessibility of media. We have got so used to the real-time reporting of the court proceedings. Many times the media picks up on the oral observations made by the particular judges, even if it may not reproduce itself in the written order. And sometimes the oral observations have had a significant effect on how the parties believe that their case is going ahead. And finally, even if whatever preparation one may do, there's something that there would be something which would be unforeseen, like it happened a few years back in a BBC interview. And I'll just play out the clip for you.
Scandals happen all the time. The question is, how do democracies respond to those scandals?
And what will it mean for the wider region? I think one of your children has just walked in. I mean, shifting sands in the region. Do you think relations with the North may change?
I would be surprised if they do. Pardon me.
That's right, carry on.
My apologies.
What's this going to mean for the region?
My apologies. South Korea's policy choices on North Korea have been.
So as you would have seen that there was an unwanted intrusion into the room. There could be all sorts of possibilities which may happen even as you're attending a virtual court. Something similar happened with me, but thankfully nothing was recorded on camera. I was able to keep my kids away from the video screen. And that's something that we need to learn to live with. So it's just that the virtual courts are here to stay. We need to ensure that we have all the capabilities. We learn as to how to use the equipment, and hopefully the technology upgrades itself so as to allow better participation in the hearings. That would be it from my side.
Right. We'll quickly take the question from our participants. Now, I think we have the same question from uh, most of our participants. Are the courts planning to continue this virtual court system even after the lockdown?
It is difficult to say. Let us see how whether the lockdown gets extended and on what terms the lockdown is extended. What is the bar associations and the judiciary? How do they take it? Uh, Officially, it's difficult to make any prediction, but I do believe that it is there to stay, even if it's not there in the courts. Maybe in arbitration. We have seen a lot of arbitration hearings which are now globally taking place through the virtual through platforms. Parties which are across various jurisdictions are being connected. And just today, in one of my arbitration hearing, the other side wrote wrote an email for adjournment, and I said, "Sorry, we are opposing, and we can have it through the any of the technologies which are available." So, uh, as I understand it, the courts may open, but it's difficult to say that virtual courts will not be followed. There are, we have seen the court sitting in dead of the night, hearing urgent matters. Maybe those kind of hearings can take place through the video conferencing. The parties don't really need to go and barge into the judges' rooms, or the judges need to come late at night to the courtrooms to hear the matter. So it's possible that the going ahead, virtual courts will be used for and used more regularly now that we have used the technology once and upgraded our systems to that.
Right. Just to quickly sum up what I felt are the important points and the important takeaways from today's discussion. One of the most important things I think right now is the dress code, because like you rightly mentioned about the Rajasthan courts fiasco, and it was all over the place. It was everywhere on social media. Even people who are not lawyers, they were discussing this over a cup of tea at home. I think the dress code is very important. It's not just, I mean, not just right now when we are talking about virtual courts, but even in future, if we do have more scope for for making this the new normal, I think probably the different courts will come up with their more strict guidelines and SOPs as to what should be the dress code, how should be your conduct. Then, as you rightly mentioned about where exactly are you sitting, that is also something that is important. I mean, like you mentioned about the Western Bar Association's letter from Honorable Dennis Bailey about a male lawyer who was not properly dressed, or a female attorney who was still in bed and she had the sheets around her. So I think these things are definitely making us learn every day how to make virtual courts the new normal for us going forward. And of course, thank you so much for all those funny clips in between. It was really interesting and funny, especially in this depressing situation when we are all under lockdown. Just before we end the session, I would like to quickly share my screen for all our participants, and I would like to show our platform to our participants. I'll just quickly show our platform. Now, this is our platform for our participants, ebclearning.com. I have already provided the link for it in the chat box as well. Now, all those who have not yet subscribed to our platform, please do that. The subscribe button is on the right hand side. You can subscribe and you can get access to our all our courses and all our interviews and panel discussions that we have. So we at present we have a wide range of law courses, which include arbitration, then IBC, corporate assets valuation. Plus, we have courses on drafting essentials. Then there is another interesting course that I would probably want to suggest to our participants, to our young lawyers, as well as to our students. It's essential skills for the legal profession. I think it really makes sense to mention that particular course today during this session, because we were, of course, talking about the virtual courtroom etiquettes and how to conduct yourself during the virtual trials. So I think this course could again be a good add-on for our participants if you subscribe to our platform. Plus, of course, we have a number of learning paths that we have been developing. One of them is on insolvency laws, and we have actually developed quite a number of courses and panel discussions and case laws, case studies, and all these things which are related to insolvency laws. We are planning to do more such learning paths for other subjects like arbitration as well. Now, with this, I would again like to thank Amit for such a wonderful session. And I thoroughly enjoyed the session, especially to learn about what could possibly go wrong when we are in the virtual courtroom. And I think all those rules, of course, apply to the other virtual meetings, virtual classrooms that are taking place. I think it's very relevant in today's time, especially. And I think I'm hopeful that probably we could probably see that there are more SOPs and more guidelines which are given by the different courts in the near future, so that
Yes,
if it does become a new norm, then probably later on people will not have to face embarrassing situations. And of course, it was really good that you discussed and you described the procedural aspects right now in the virtual courts. And I think whatever you spoke about how to file and then how the process actually happens, what is the timeline, I think those are very important and relevant. Thank you so much, Amit.
my pleasure.
Thank you very much. And thank you to all our participants for joining us today in this new normal, which is a virtual interaction and discussion. Thank you so much.
Thank you.